This isn't just a courtroom hearing, it's a countdown. One defendant, 50 phone calls after arrest. A judge losing patience in real time. In minutes, freedom hangs by a thread, and the final decision changes everything. Watch closely, because this case takes a turn no one expects.
Calls her 50 times. So I have concerns given that also to Raymond, the magistrate indicated his concerns that he will not follow court orders and that he would go back to contacting the victims.
All right, pause here. This is where things quietly turn serious. When a case gets set for exam, that means the court is deciding whether there's enough evidence to move forward. This isn't guilt or innocence yet. It's about whether the prosecution can even clear the first legal hurdle. Question for you. Should repeated behavior after arrest influence that decision this early?
When was he released?
I'm sorry, could you?
When was he released from jail?
I believe it was the 26th, and he was arraigned on the 24th after being arrested on the 23rd. Could I attempt to respond, Your Honor?
Go ahead.
My response is primarily based on the facts of the case. This complaining witness stated she was not assaulted. The grandma did not witness any sort of assault. As the prosecutor told you, she said she heard something. So there's no
50 calls. After arraignment. Let that sink in. Once a judge sets conditions, especially no contact, every single call matters. Even one can be a violation. The court isn't just hearing numbers here. It's evaluating risk, safety, and whether court orders mean anything at all. Do you think intent matters more here, or sheer volume?
be told 3 times to turn around and 4 times to back up. And that's a felony. And now we want to revoke his bond, which is basically a due process violation because you take away his trial right. His trial will be in about 8 months.
Why am I taking away his trial right?
Because if he's incarcerated, then it's make a get out of jail plea. I mean, he's talked to.
It's not, counsel. And quite frankly, this court resents that you even make that argument that this court would be involved in violation of anybody's due process rights. He's given conditions. If he does not follow those conditions, he pays the consequence.
I agree. I just indicate to the court, I don't think the person that the condition is regarding wants that condition. She didn't want any of this. And then
there's a way in which that's taken care of, not by him continuously calling.
This exchange right here is pure courtroom tension. The judge isn't asking casually. This question is about timeline credibility. If release happens, then violations stack up fast. Timing can make or break a bond decision. Watch how quickly patience starts to wear thin.
I have an argument to that, but if the court would let him stay out to the 13th and he's not going to contact.
I don't know what he's doing now. I mean, that's what part of the problem is. Part of the problem is that, and by the way, not only is your client entitled to due process, but the people are entitled to due process. Everyone is entitled to due process, and it is my job to make sure that it happens. If I believe for whatever reason that he may be interfering with the people's due process rights to fairly present their witnesses and have their witnesses present, then I'll take action, which I'm about to do now. Right now, his bond is revoked. Defendant is remanded. Thank you. Yes, and his phone privileges while in jail are revoked. Put that, can you?
Would the court only revoke as to the 2 persons with no contact orders?
I'm revoking his phone privileges.
Okay, thank you.
State your name.
Joseph Hafner Cantor.
All right, what are we doing?
Your Honor, we're asking for a preliminary examination at this time.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me.
Where?
Bond continued. Thank you.
I think the last time we were here was December the 4th.
Pardon?
Last time we were here was December the 4th. I have a violation dated December the 9th. Bond violation, of course.
Here's the defense strategy in a nutshell. No eyewitness, no clear assault, conflicting statements. That's textbook reasonable doubt. But bond hearings aren't trials. Different standards, different goals. The real question is this: should bond be about punishment or prevention?
Yes, I have December 4th, and I've got,
So it does appear that these tests were in the interim period between the last time we were here and this
Mr. Allen.
with positive alcohol blows on the Silverlink.
I've got a positive on December 8th. And then missed tests really through the 9th, early into the morning. So the 8th was at 11:37 p.m. 0.07. And then 04, probably the same alcohol, maybe a little bit more, by 8 a.m. that morning. So some 8 hours later, he's still blowing numbers. Except that then a little bit later, it popped up and then went down. So it looked like he was continuing to drink. Then the worst thing happened. They spoke with him, and he said he didn't have any alcohol.
And Your Honor, I believe Mr. Hafner Cantor is changing his position on that now.
Really?
He
Yes,
did appear on the same day that this violation report was submitted. He appeared before Judge Frushauer to be arraigned on a misdemeanor OWI. The misdemeanor OWI date of the alleged offense predates this case. I think it was just authorized later due to lab results. But nevertheless, he appeared for arraignment knowing that this violation was there, and it was addressed at that time by Judge Frushauer, who had him taken into custody with a $5,000 10% bond. I think the condition of that bond,
On this case?
he was taken into custody at the time of his arraignment.
You're saying two different things to me. Her taking him into custody at the time of the arraignment is one thing. If she's taking him into custody on this case, that's a different thing, and not something that I see in this file.
And you're correct. What happened was, after the court considered this bond violation and received the report from his tether agent, bond was set in the amount of $5,000, 10%, with the condition that he be fitted with a scram tether before that bond shifts to a personal bond. So he was fitted with a scram tether. He remains on that scram tether since December 9th, and I don't believe he's had any violations. Mr. Hafner Cantor is employed and has stable housing with his employer in Saline. Your Honor, I would ask the court to consider continuing his bond, because I think him being on a scram tether is kind of the constant reminder he needs not to drink. I will note the present offense. I don't believe there are any alcohol related allegations, but of course he does have a misdemeanor OWI, and he admits he has a drinking problem.
And there it is. Bond revoked. This isn't about Christmas, age, or sympathy anymore. This is about compliance. Judges have wide discretion here, and once they believe court orders are being ignored, the hammer drops fast. Did you see this coming? Or did the defense have a real shot?
It does appear to the people that alcohol is a significant problem for the defendant. It appears that the Silverlink is not working. So I would ask that the court, at the minimum, order the scram in this case as well.
Did he take the ETG?
Doesn't look like it from this report.
I did not give you one.
So there was a warrant issued on this one. Okay.
Okay.
Is it still out?
For Mr. Hafner.
Yeah.
Okay.
No, I do not see that one.
Oh, you do not see that
I
one.
do not see, no. So the report says, I advised him to report to community corrections for an ETG urine test by end of the day. This is on 12/9. He said he had court and only had transportation there, doesn't have any money to take the urine test. I advised him a violation would be sent, and I was affording him the opportunity to take ETG test to provide results with my report if in fact he was not drinking. And I just confirmed with Mr. Cook. Mr. Cook informs me that the defendant had a positive BAC coming into court. I'm not sure if that's related to this violation report or if it was actually going to court, but it does all appear to be on the same date, that December the 9th sort of time frame.
So when did he appear before Judge Freshour?
It looks like December the 9th,
That's correct.
What time?
9-ish in the morning.
So she may or may not have been aware then,
She was aware, she remanded him, and
but was she aware that he was intoxicated?
Mr. Cook's note indicates, and his communication to me indicates that he had a positive BAC coming into court. I'm assuming that means he was blowing numbers at court. And I know that community corrections was there.
Okay, I'm pretty much done. I mean, you drank coming into court, you drink in violation of my bond. I saw you 4 days beforehand. And no,
May I speak?
we don't do that. Say whatever you want.
Your Honor, I think what Mr. Hafner wants the court to consider is that since this string of events leading up to the court date on December 9th, I think he has pivoted and changed his position from denying
So let
his
me get this
problem.
right. You're telling me that all of a sudden everything has changed. On December 8th, he's drinking. He's drinking well into the morning on December 8th. He has to appear in court, can't stop drinking, and then ends up at court that day. He talks to community corrections, I think, on that same day and just is absolutely lying to them. And somehow between now and that date, he has made a certain epiphany has occurred and he's made some miraculous transformation. Is that what you're telling me?
Your Honor, I understand the court's concern. Mr. Hafner Cantor, when were you released from the Washtenaw County jail? Was it the following day or this?
I was there for a week. I think I was released on the 19th or the 18th.
So, Your Honor, he's strung together 10 days on a scram tether with no issues whatsoever. And I think that's what he wants the court to consider in reassessing bond here. I would ask the court to continue his bond based on the fact that he's come into compliance since being placed on the scram tether.
He's in violation on my case, goes to another court drunk.
And Your Honor, I would like to correct my record I made to make sure that it's accurate. Mr. Cook has let me know that he doesn't know if the defendant was individually touched at the court, but because he had the .04 30 minutes before the judge saw him, Mr. Cook's note was that he was drinking. So I apologize if that was confusing at all. I just want to make sure.
So he wasn't breathalyzed at court.
Now that Mr. Cook is aware.
Where?
But
It's because it was 30 minutes before, there was an assumption which is a good assumption.
it's pretty fair, yeah.
Anything else?
Your Honor, I know Mr. Hafner Cantor's been in constant contact with his community corrections agent, and I know that his 3-year-old daughter, who he takes care of, is his biggest concern. I think he was dealing with some stress regarding a custody situation with respect to his daughter, and
He's violated my bond. And then absolute disrespect showed up at another court, still under the influence of his drinking event that violates his bond in this case. And he's appearing at that time on an OWI. And he's not in any treatment. Anything else?
This second case is where patterns matter. Alcohol violations, inconsistent explanations, drinking before court. That's a nightmare scenario for any defendant. Judges don't need miracles. They need consistency. Final question for you. At what point does second chance turn into too many chances?